What is termination of obligation for unmarried sons and daughters of US citizens? Imagine sponsoring your child for a green card and wondering how long you are responsible for supporting them financially. That's where the idea of termination of obligation comes into play. When a U.S. citizen sponsors their unmarried son or daughter, they sign a legal document called an affidavit of support. This document is a promise to financially support the family member so they don't rely on government benefits. But this promise doesn't last forever. It ends when certain conditions are met. One way the obligation ends is if the sponsored person becomes a U.S. citizen. Once they have their citizenship, the sponsor no longer needs to support them under the affidavit. Another way is if the sponsored person works enough to earn 40 qualifying quarters of Social Security earnings. This usually takes about 10 years of work. If they leave the United States permanently and give up their green card, the obligation also ends. And of course, if the sponsored person passes away, the support obligation stops immediately. It's important to understand that this support obligation is based on the legal agreement signed by the sponsor, not on the family relationship itself. Even if the relationship changes, the obligation remains until one of these specific conditions is met. For Latino families, this means that sponsoring a son or daughter involves a long-term financial commitment. If your child becomes a U.S. citizen or earns enough work credits, your responsibility ends. If they leave the country permanently or pass away, your obligation also stops. This rule helps ensure that sponsored family members won't become a burden on public resources. It's a key part of family-based immigration and helps keep the process fair. If you're thinking about sponsoring a son or daughter, it's good to know these details beforehand. Planning ahead can make the process smoother and help you understand your responsibilities as a sponsor.